All right, I'm gonna go ahead and get started. I've got 1 o'clock on my clock, so we're gonna go ahead and get going. Thank you all for being here today. We have a pretty good crowd. Let's go ahead. We're gonna just take care of the formalities really quick, which is 14 is 13 is 1. Yeah, right time. Okay, so we'll take care of the formalities really quick. There's where we are, the Association of Realtors. We're going to talk today about the listing agreement, and it won't be quite as harried as we're normally going through because this paragraph is not that long. However, there's a lot to talk about because it has to do with what happens when we don't get along, what happens when we don't tell our manager about things. And so there's going to be some subjects in here that we're going to discuss. We're going to be talking about stuff that's going to appear to be legal, and I don't give legal advice, and I do a lot of trial work. I hate to admit to it, but usually defending real estate brokers. I've got a couple that I'm not going to defend, but anyway, it just is what it is. Not intended to be a substitute for the advice of your broker. Please listen to what your broker has to tell you. If I'm your broker, then yeah, you always listen to me. But anyway, so thank you for those of you who I'm your broker. And then not a substitute for the advice of your attorney. So, certainly you can get good legal counsel anytime you need it. Let me know. Happy to hook you up any way that I can. And there's my email address. If you're not getting my email on a weekly basis, send me an email. I'm not going to put you in there unless you ask me to do it. So that's just how all this works. Okay. And I'll pop this email address up towards the end as well, a little bit later. Robinson, welcome back. There's Galena, welcome back. Okay, good. All right. So that being said, we got the introductions out of the way. I got to tell you, I am dying to do live classes again. We're going to have to do something. So I'll be back there at the association probably in the next couple of weeks doing live classes, but I'm talking to them right now about also having a piped in component, only because, for some of us, it's really easy to be able to do this. You're not driving, you're not fighting traffic, you've got a lot of other benefits for doing that. So going to have to figure out a hybrid on how to do that. And I'm talking to the board about it now. So in fact, I just got off of the executive committee call. So that was good. Okay, that being said, let me start up a new share for you. We're going to get into the subject matter that we're on today. And today we're going to be talking about management approval. And a lot of people are going to, wonder what it is I'm talking about because in some places, we don't really give it to the manager. And so having been management at 3 of the largest brokerages in San Diego County, I can tell you, some of them I had 185 agents. And so some of them I would get that note, I would get that file dropped on my desk a couple of, a day, maybe a day, sometimes it already closed, and I would get the file on my desk and it would be like, here, I'm giving you the file, go ahead and pay me. And so there are going to be some issues in here that we're going to want to talk about. So this is the listing agreement. And so you need to be aware of the fact that DRE requires that you get copies of all material to your manager, to your broker, within 72 hours of you getting it signed by anyone. And remember that they're going to call this a material fact. So these are material pieces of paper, material things that you have to have in front of your broker within 72 hours. Now, your broker can have another contract with you. They have to have a contract with you, okay? Otherwise, that's a DRE violation in itself. And that contract with the broker can specify a shorter time. So, for example, our contract says you'll get it to us within 24 hours. So we can make the time shorter. We can't make the time longer than the DRE required 72 hours, okay? So that being said, a lot of times I was getting them as they were closing, and that is clearly going to violate a 72-hour, much less a 24-hour rule that file be put in front of the broker. So please try to remember that. Sometimes we kind of lose track. We get stuck in this big pond that we don't know what's going on. But you have an obligation, whether you are a salesperson or a broker associate, you have an obligation by DRE regulation to get your paperwork to the broker. And so what's material? Well, it's going to be anything signed by a party for sure, right? So anything that a party signs in a transaction needs to be in front of the broker. Now, I have had brokers that I've worked with who have said, did the deal come together? And I say no, and they say, okay, then I don't need it. Well, the answer is, I don't know. I think you do need it because it is a material fact. That is paperwork that has to be approved by the broker, and because the DRE is going to hold the broker responsible, so the broker needs to see that stuff. Okay, all right. So and you can't contract out of that. So just please remember, anything that you get that's material to a transaction, clearly anything signed by a party, got to be in front of the broker within 72 hours, unless your contract says that it's less time than that. So 48 hours or 24 hours or whatever. Okay. Now, some brokerages are using the cloud as a way to get their paperwork from their agents. So for example, creating Dropbox accounts or things like that. In our office, we use zip forms. I'm assuming you will too. And we maintain that we have the broker version of zip forms. So when our agents do things, when they write offers, when they write listings, we can see it instantaneously. We are still liable for it. We still need to be reviewing those files. Okay. So that's, so it's really, really important. It's not just, a CAR contract item between the seller and the broker. It is part of a much bigger picture. So let's take a look at this paragraph, because this paragraph has a lot of stuff in it. So I know I'm limited on time, but only in that I've got to get us out of here by 6 o'clock. So hi, Deanne, welcome back. James, welcome back. All right, so let's talk about these things. So we've got management approval. So this is going to be my paragraph number 17, one of my favorite paragraphs, the one that nobody ever reads, right? Because it's one of those paragraphs that is in the pre-printed language. And when we start looking at agreements, we make the mistake sometimes of just scanning over the stuff that's pre-printed. I'll get back to it when it's important. I'll read it later, whatever. Listen, I wouldn't do that, okay? So bottom line is, you need to make sure your management's looking at stuff, and you have, the DRE says you have to have supervision. So broker supervision is one of the highest investigated items at the Department of Real Estate. Duty to supervise. When I see complaints against brokerages, I see them, and it's almost always that when something goes wrong, that's a bucket for DRE. So please, let's try to be consistent. Let's try to follow the rules, and let's try to get that information in front of our broker. So if an associate licensee in the broker's office, so an associate licensee just generically is going to apply either to a salesperson or to a broker who is not the responsible broker. Okay, so again, the salesperson or the broker salesperson who is a broker associate enters in this agreement on the broker's behalf. So when the broker doesn't enter into themselves, so they're not at the appointment, and the broker or manager does not approve of its items, okay, now this is important. I kind of call this like the kick-out clause. So, and the broker or manager doesn't approve of its terms, the broker or manager has the right to cancel this agreement in writing within 5 days after its execution, okay? Within 5 days. So think about that for a second. If you don't give the paperwork to the broker until the day before it closes because you want to get paid, because you think that's all that this is about, then you've created a problem for the broker, because you might have something in this agreement that the broker is going to say, oh no, I can't agree to that. That's going to be one of those things that's just going to get me in trouble, or it's potential for a lawsuit, or it could be causing other things like that. So, what our responsibility, and I'm a broker associate under Linda at Burke Real Estate Consultants, even though the company has my name on it, I gave it to Linda because I'd rather teach and work on lawsuits. So, but I'm a broker associate. So anytime I have anything signed, I make sure Linda has it. My contract with her says I'll get it to her within 24 hours. So, I'm okay with that, right? I think once I got it in my hands, get it out of my hands, give it to the broker. It belongs to the broker, okay? It doesn't belong to you, it belongs to the broker, okay? All right. Again, unless you are the broker for the company, not a broker associate. So how much time do you have? You got 5 days. The broker's got 5 days to kill it. The broker's got 5 days to say, I can't do this deal. Okay, you've asked me to do something that I don't, that I can't do, and maybe there to protect you, the agent. Maybe you're doing something in the contract, you've decided to agree to something, but remember, the broker ultimately is responsible for that agreement, so you have to make sure that it has terms and conditions in it that are favorable or at least acceptable to the broker. Okay, so here's the thing, again, if you don't give it to them within 5 days, then they really don't have much of a chance to kill it. Okay, so maybe you don't want them to kill it, maybe you think it's okay just to kind of force it through and hope they don't notice. I don't think I'd like that case. Okay, so for you and me, remember, DRE says we have to get that material issue, prelims, stuff like that, to the broker within 3 days, 72 hours, unless the broker has a contract with us that says less time than that. Okay, and that gives the broker 5 days. So my key terms are 1 day, 3 days, 5 days, because 5 days is the magic day. That's it down here. This is the DRE regulation, and this is your contract with your broker. Okay, all right, big deal. Those are big deals. Okay, and yet again, as I said, having been management, in 3 different large companies, sometimes we would get it until the end, and it's like, and then you wonder why your check is held up. You wonder why the broker doesn't want to pay you right away, because you're not giving them really, in addition to the fact that you were supposed to get it in there, you're maybe not giving them enough time to review the file. I want my check now kind of thing. It's like, I need time to review the file, and you're not giving me the time that the DRE is requiring. So this is an incredibly important paragraph. All right. And so, if you're doing a lot of transactions, then you're going to figure out a way to do it. Maybe you scan it and send it to the broker. Maybe you put it into a Dropbox account. Maybe you load it up into zip forms, and now the broker can go in there and pull it themselves and take a look at it. Again, please notify the broker that it's in there so that there can be some accountability on that. Okay. You want to be held accountable, because at the end of the day, you don't want to be standing out there on your own. The broker's got a policy that says you'll give them everything within 24 hours. And guess what? The broker is going to separate themselves from you. If there's a problem later, the broker's going to say, well, we have a contract that says you're going to get it to me within 24 hours. Now there's a problem. There's a DRE audit, or there's a trust money missing, or whatever. You're not following office policy. And so, maybe we don't like having that connection anymore with you. And so remember too, the broker is probably carrying errors and omissions insurance. And so a lot of these things, whether or not you're following the broker's policy, are going to impact whether or not there's going to be coverage. Okay, everybody good? That's a big thing. Okay, so it's a big issue. Any questions? Seeing none, I will go ahead and move forward to the next issue. Like I said, today, I'm giving you big stuff, but you got to ask me questions if you have any questions or concerns about any of that. Okay, so the key ingredient in here is the broker manager has the right to cancel this agreement in writing. It has to be an express cancellation. So the broker just says, nope, we're going to cancel our listing agreement with you because we don't have what we need. Now, please don't get in your head that you don't want that to happen. There may be a reason why that's going to happen. And so you need to make sure you check with your broker. And as we said earlier, we love our broker. We want to make sure that our broker is safe. And this is one of the ways of doing that. Okay, so the DRE requires that the broker be watching their files, going through all their files, but they can't go through the file if you haven't given it to them. Okay. All right. Okay, let's take a look at paragraph number 18. Any questions on any of that? No. Okay. All right. Let's talk about paragraph number 18. I get this a lot. People ask me, and this is on the state exam, people ask me the question of whether or not the listing agreement is binding anyone who gets the property after the seller, either passes away or loses the property or whatever. And so this is going to be the answer to that question. Paragraph number 18 says successors and assigns. And so again, this is the listing agreement between the seller and the broker. So this agreement shall be binding upon seller and the seller's successors and assigns. So in other words, we want to at least have a case to argue that everybody understands that if you hypothecate this property, that if you give this property to somebody else, or if you lose this property other than through foreclosure, then we have a right to enforce our interest in it. Okay, so if the seller loses the property to foreclosure or to trustee sale, then excuse me, there's not much we're going to be able to do about that. But the seller has other issues to deal with at that time. Okay, any questions on that? All right, good. What was it, Mike? You said earlier today that I was doing my stuff like my hair was on fire. So we're not going to go quite so fast on this one. So okay, let's talk about our dispute resolution. And I don't mean to give you the impression by looking at that it's got a very small field down here. Let's talk about my dispute resolution. How do I handle the possibility that we don't get along? So there's nothing here. That's because we're going to go to another page. Okay, so here's my dispute resolution paragraph, and we're going to talk a little bit about this because this is going to bring in a couple of things. let me tell you a little bit about history. It used to be, first of all, all of our agreements, our listing agreements, our buyers representation agreements, our purchase agreements, we kind of want everybody to mediate first. And there's a compelling interest in doing that. And that is, if we can get everybody to mediate, it may have been, we might be able to actually quelch the problem before it becomes a big deal, and certainly before it becomes a very expensive deal. So, because the minute you start heading to court, it's going to get expensive. Okay. So we're going to talk about that in just a second. First of all, we want to encourage people to mediate. Mediators are trained. They have skills to hopefully get everybody to agree to something. You have an obligation by contract to attempt mediation. You don't have to agree to what the mediator does. Okay, so the idea behind the mediator is to give them the task of coming to an agreement, getting the two parties to come to an agreement that the mediator can get written down. And so if he or she can get the parties to agree to something, the mediator will then write it down. It becomes a contract. And now we're going to go ahead and we're going to, if everybody agrees to it and signs it, now we have contract rights, versus before we're going to be suing on a different contract, which would be on this contract. Most of our lawsuits in real estate on the seller side are commission based. So usually it's some kind of a problem with, you didn't do your job, or I'm selling the property to somebody else on my own, I'm not going to pay you. So most of our disputes are usually based on commissions. I was not party, but I was aware of a lawsuit where the seller just did not like the agent that had the listing, and so did not like this person that they refused to pay them. And so at the end of the day, the individual that the individual broker associate was going to have to litigate to get their commissions, because they just upset this person so much. Can't imagine what they did, but they did something. This person was not going to pay them. So as a brokerage, we would take up that banner cry. But again, but we would have to make a business decision as to whether or not it was going to be practical for us to do that. So for example, based on a commission split that somebody might be on, we might, as a brokerage, make the decision, hey, you know what, it's not worth the fight for us, because, even if we win, we get, nickels, that kind of thing. Does that make sense? So, that's going to be a consideration. Everybody thinks, oh, the broker's got to paid to defend me. Well, the answer is, yeah, paid to defend you, but not paid to file lawsuits. Most brokerages don't like to file lawsuits. Most of them are in a defensive posture, not in an offensive posture, if that makes sense. So let's talk a little bit about mediation. So I'm going to have three different things I'm going to talk about. We're going to talk about mediation, and that's going to fall under my category of ADR. ADR is alternative dispute resolution. So I'm going to have my mediation, I'm going to have my arbitration, and then I'm going to have my litigation. Okay. Now, mediation, again, in our CAR contracts is always the default language. Okay. Everybody agrees to it. Now, if there's a dispute and everybody agrees that they're not going to mediate, they're all going to go to court, not just one party sues, but everybody says, skip mediation. We're all going to sign a document that says that we're going to sue each other, then that might be a different issue. But at the beginning of things, we want to at least attempt to have the transaction mediated, or in this case, the commission dispute mediated. Okay, so let's talk about that a little bit. So mediation, seller and broker, because that's who sorry, I do this every time. Okay, seller and broker, because that's who my parties are, agree by contract to mediate any dispute or claim arising between them regarding the obligation to pay compensation. And that's what I said earlier. Almost every single lawsuit we get involved in between the broker and the seller are almost always commission-based, okay? Remember I told you in a previous class that most of our lawsuits come from the buyer. The buyer is usually the one who litigates, I was wronged, now I own the property, I didn't know what I was buying, whatever. But in a listing agreement, we usually have the seller involved with the broker in a lawsuit, and it's almost always about agreement to pay compensation, okay? Does that make sense to everybody? Okay, so regarding the obligation to pay compensation, paragraph number 3, right? Under this agreement, before resorting to either arbitration or court action. So as I said earlier, you know, I've got a couple of choices going down the path here. We don't like gunplay, right? We don't like to get that stuff going on. But what we do like is we do like everybody to try to work it out. We'll hire somebody that's skilled in negotiation strategy, that kind of thing, to maybe come up with an agreement. Okay, so arbitration, litigation, hey, I'm fine with it. Whatever you want to do, I think you should try mediation first. All right, so the mediation fees. So if you're not familiar with it, here's how it normally works. So that you go into the mediator's office. It's almost always in the mediator's office, okay? I remember the last mediation I was involved in. I remember it well. I remember the individual that did it. I remember his name, his name. I remember his company. I remember the whole thing. And this was 20-something years ago, okay? So I don't get involved in a lot of mediations. Usually I get called when it's litigation and maybe an arbitration. So, but for me, you know, I was personally involved in a mediation, and we all agreed in the mediation. So here's what happens. You got the mediator. The mediator sits up at the head of the table. There's this long table, and parties are on each side, just like this. Parties are on each side, and they're looking at each other, and the mediator gets up there and says, okay, so are we going to be able to work something out here? And if the parties say, sure, we'll give it a shot, because remember, you have to make a good faith effort in it, okay? In our case, everybody said no. So we, you know, so what do? We each cut the mediator, and I don't know what the bill is today, but we each cut the mediator a check for $250 and gave it to the mediator, and we all left the room, okay? Now, I'm going to tell you, I probably wouldn't do it that way. I was successful in litigation later. You know, I prevailed in that case, but I like mediation, folks. I really do. It's important to me. So, but everybody is going to agree to get that issue done. So my mediator at the head of the table here, what he'll do after everybody says, yeah, we're going to mediate, he'll take, you know, everybody from this room will go over to another big room. Everybody from this group will go over here to another big room. And then what will happen is the mediator will go back and forth between the two. Okay, everybody follow me? The mediator will go back and forth between the two. So they'll start in the one room, whichever one it is. I shouldn't say that. I was involved in a mediation, but it was for a client about 6 months ago. It was actually pretty well done. I was pleased with the court appointed mediator, but the you know, again, at the end of the day, we try not to get into a dispute, but if we are, we need to talk about how we're going to handle it. So in the situation where the mediator goes back and forth from room to room, he goes into one room, he says, you know, okay, you know, I heard your side of the story, because that's what everybody does in the big room. Everybody tells their side of the story. And then you go over to the, you know, he goes over into the one room where the one group is, he or she, and the one group where the one side is, and says, okay, tell me what you got. And then they tell him what they have. And then he goes over to the other, he or she goes over to the other room and says to them, okay, tell me what you got. And then they tell him, they say, well, but they got this. So this other side's got this. And I really think that, you know, they have you on this, but they don't have you on that. We agree about that. You know, what can we work out here? And so that's what the mediator does, goes back and forth in between the rooms normally and comes up with some kind of an agreement that, assuming you can get everybody to agree. So remember, you have agreed to mediate, but you have not agreed to finalize it. So you literally are there to do the mediation, but you are not necessarily there. You are not compelled to accept what the mediator works out. But if you are, okay, and by the way, if you can't get it together, if the whole group can't get it together, then everybody leaves and we go on to the next level, which is going to be either our arbitration or our litigation, depending on what your contract said. Okay, all right, so if you all agree, if you come up with an agreement, then the mediator sits down and writes up that thing we call a contract, and then everybody signs that. So obviously you wouldn't be in mediation, you know, except that maybe there were some variables that didn't make it really, you know, obvious that it had to go one way or another. But now we're going to create a contract that says you're going to agree now to be bound by the agreement that you just made. And then if everybody signs that, then we're done. We've got, you know, we don't go any further. You're done. You now have a contract, and mediators are trained to create that contract so that, you know, you're bound by it. Okay. Mostly, they're usually practicing attorneys. I know quite a few mediators in San Diego County, and they're all attorneys. I'm sure there are, you know, you don't have to have an attorney do it, but we'll talk about that when we get into arbitration. But most of them are attorneys. So, and some of them are actually pretty good. So, and in fact, San Diego, the association has the risk management, REMC, where we do mediations. So right in the back there of the, 4845 Ronson Court, we do it right behind the big building in the back. We own that one as well. And so we do mediations back there, but we also do arbitrations back there. We also do professional standards cases back there. There's a lot of stuff we do back there, okay? But if everybody comes to an agreement and everybody signs it, we're done. We don't go anywhere else. That's it. Now we've come to settle, we've settled it, and we're going to move on with life, okay? Now, if you don't agree to it, and you've only got a certain amount of time to do that, they're not going to do this all week, then we'll have to go on to the next level, okay? Are there any questions about any of that so far? No. Okay. All right. So mediation fees, if any, shall be divided equally among the parties. And I told you that when mine was 20 years ago, it was $250 from me, $250 from the other side. And each of us paid the mediator. They made $500 for essentially an hour's worth of hearing our story and then deciding that we weren't going to do it. Okay. All right. So, and it has to be divided equally by contract. Okay. If for any disputes or claims to which this paragraph applies, any party, one, you need to know this, any party, one, commences an action without first attempting to resolve the matter through mediation, okay, or two, sorry, I'm going to get rid of that keyboard, I don't need it, or two, before commencement of an action refuses to mediate after a request has been made, okay, so after those two things, all right, so you went straight to the lawsuit, that's not going to work well, okay? All right, so we don't want to do that, okay? So for any dispute in which claim of this, any party commences an action without first attempting to mediate, or before the commencement of an action refuses to mediate, then that party shall not be entitled to recover attorney's fees, even if they win. So that's why, most of the attorneys that are out there, before you're going to get anywhere, they're going to say, hey, no, you know what, you got to at least take a shot at this, because if you don't take a shot at the mediation, it doesn't matter whether you win or lose at the next level, you're not going to get your attorney's fees. So, it's going to cost you. So let's at least attempt the mediation. Okay, everybody good? Now remember, for those of us that are working for a brokerage, it's the broker's decision whether or not, what to do, okay? Whether or not the broker wants to, they've agreed by default language to mediate, but we're going to see in a second that there is no default for arbitration or lawsuit. We're going to have to physically make that decision, okay? The broker will have to make that decision. So just remember, if you move forward into lawsuit without at least attempting mediation and you win, you might win, but you're not gonna get your law fees. You're not gonna get your attorney's fees, okay? Even if they would otherwise be available to that party in any such action. So even though you win, and even though everything else said, hey, you know what, you get your attorney's fees if you win, the fact that you didn't go to mediation first, you don't get your fees. Okay, so have your lawyer explain this to you, but this is pretty damning information. All right. Okay, so what are we going to do? We're going to try to mediate first. And again, it's a decision for your broker. Anytime you get a letter from a lawyer, would you all do me a favor? You get a letter from your lawyer, take it to the broker right away. Anytime you get a letter from the lawyer or a letter from the DRE, chances are pretty good they've already seen it, but you need to get a hold of your broker right away. Okay, because sometimes you got it before they did. Okay, and so you need to make sure your broker's aware of, remember that duty to supervise, you need to make sure your broker's aware of what's going on in your file, and that includes anybody that's threatening you. So anybody that's threatening you, remember, you're the sales associate, and that's a convenience at a certain point, but it's also a requirement that you make sure your broker's aware of that, because you certainly, I've had this happen where the individual contacts the attorney and says things to the attorney that end up compromising their broker. And so, that's why usually the attorney sends the letter to the individual and then also to the brokerage, but the brokerage doesn't get it sometimes before the salesperson gets it. So that's going to be kind of an important deal. All right. So please do me a favor. We love our broker. We want our broker to be okay. Make sure that anytime you hear, you get any kind of a dispute from anybody, you make sure that it goes straight up channel. Make sure it goes straight to your broker. And let your broker be aware of it, and then your broker will decide what to do with it. I've been in companies where the broker just said, okay, you're done, go on, do something else, go do it, sell another house, I'll take care of it, okay? I've talked to some really big brokers who have said, no, listen, we just move it up and drop it on the attorney's desk. We have in-house counsel, whatever, we drop it on the attorney's desk, let them handle it. And in most cases, the real estate agent never hears about it again. So, you know, it's one of those things where they figure it all out themselves. But, you know, if you get involved and get brought into something, let's make sure that you have done everything by the book. Okay. Make sure you're doing things the right way. Okay. Everybody, any questions on anything we've covered so far? Let me see here. Ah, Seraphine, welcome. Okay, all right. So I'm just checking everybody out, see who's all here. Okay, so we covered what happens, right? You got mediation first. And again, I said this before, this is in all of our agreements. So we're always going to attempt mediation first. And if we try to do something other than that, then we don't get our attorney's fees. And so you don't have to worry about that because you're going to hand it to your broker and your broker's going to hand it over. And if I'm your broker, then, you know, give it to me. Please let me have it. I love talking to lawyers. Okay, lawyers are fun. All right. Okay. All right. Then we have some bold print, and we have bold printed language, and those are things that we need to pay special attention to. So exclusions from this mediation agreement are going to be contained in paragraph 19B, okay? And so notice that on this form, only the seller initials. We don't need the broker's initials because the broker's going to sign it at the end. Remember that the seller, the initials on all those other pages are only for the purposes of confirming that the seller has seen it. We don't need to prove that the broker has seen it. And that's why we remove these from our employment agreements. Although the buyer representation agreement still has a place for it for the broker's signatures, but I don't know why. I think we'll move that out of there too some point. Okay, so everybody understand 19A, right? This seller initial, the point I wanted to make was this seller's initial is at the bottom of the page. This paragraph doesn't require a separate initial, not like my arbitration or my liquidated damages might require. This is just because it's at the bottom of the page. Everybody good with that? Okay, now I am not able to get, okay, where's 19B? It's not showing up. No, that's why, because I am still under the mouse. Look at that. Oh, isn't that crazy? Okay. So we want to clear all my drawings and then go back to my mouse, and it's not going to let me do that. I think my screen is locking up. James, how are you? Welcome. All right. So my screen is going to lock up on me. And now what I'm going to do is I'm going to go back, do a new share, and I'm going to grab my screen back. And that's not going to work either. So let's do a clear, and that doesn't work. So I'm going to nix out of this, and then I'm going to go back in and I'm going to grab my document again. So here we go. He says with confidence, and there it is. Can you all see that? I'm back on page 1. Here we go. I'm back on my management approval, and there was the topic that we just covered. Sometimes there's Windows 10, right? Give me a break. Okay, so we did 19A. Now let's talk about 19B and C, and this is where it's going to get fun. So everybody goes, oh, well, wait a minute. How much time do we have? God, we're half an hour. I can't believe this. Okay, guess what? This is going to be another half hour minimum, but I'm going to show you some really cool stuff so that you understand it. Remember, anxiety is the fear of the unknown. And if you know what these forms say, you won't be afraid of what somebody else says they say. Okay, so I've got a thing going on with another broker right now, and it's like there's just all kinds of stuff going on. I'm like, what is that? And obviously they don't have a clue what they're talking about, but of course they accuse me of not knowing what I'm talking about. And if I didn't know what I was talking about, I'd be fairly convinced, right? So don't worry about what these other people say. Learn as much as you can. You probably know more than most of the people that are out there. So let's take a look at our mediation terms, okay? I'm going to go ahead. I'm going to pull up my annotate button again, all right? And we're going to be talking now about additional terms. So remember, we talked about the main terms, but let's talk about some other stuff. Notice, too, that this is all in, again, bold print, okay? The following matters are excluded from mediation, okay? All right. Drink a lot of tea. Okay, excluded from mediation. So number 1, a judicial or non-judicial foreclosure. Okay, so what does that mean? So essentially in California, we don't really have judicial foreclosures. A judicial foreclosure would be a foreclosure that would go towards a mortgage. So we really don't have a judicial foreclosure. What we have normally is a trustee sale. So they call that is known as a non-judicial foreclosure. And different states do things differently, but it has to do with your contract with your with the lender. So the in this case, if the property were to be taken back, then, by the bank, then, we wouldn't have any rights to it because we are excluded from it. So the judicial foreclosure occurs in places like Florida, where they have loans, two parties, mortgage or mortgagee, okay, two parties, all right, versus in California and a lot of other states where we have three parties. We have our trustor, our trustee, and we have our beneficiary. Okay, so that's going to be my trustee state, shall we call it? All right, and so in my trustee state, I'm going to have a non-judicial foreclosure, which means they don't have to go through a court process to get the property back, but they can get it back a lot faster, but they don't have to spend as much money getting it back. And oh, by the way, they also don't have to worry about a redemption period. And in a mortgage state with judicial foreclosure, there's a redemption period, which means the borrower who loses the property to the bank, in some places, Florida, for example, has 18 months to recover the property. They can come back and get it. And the bank sit there holding on to the property for 18 months, can't do anything with it, because there's always the possibility that the borrower can come back and say, hey, guess what? I got the money. Here you go. I want to get my house back. Okay, so they like it in California. It's a lot faster process, non-judicial foreclosure, trustee sale. But once they do it, it's over. But then they also give up certain rights of chasing the borrower, things like that, unless, of course, the borrowers committed waste or done something to the property. Okay, or other action or proceeding to enforce a deed of trust, mortgage, or an installment land sale contract. So we still see the installment land sale contract language in our rules and in our laws and things like that, even though most of you won't be doing those probably in your career. They take a special, we used to do them up until the 80s. It's kind of like almost like a seller carryback. An installment land sale is where the seller sells the property to the buyer, and the buyer has now equitable title in the property, but the seller doesn't give them legal title to the property until the buyer pays it off. So it's kind of like a carryback. So the buyer, makes payments on the property. That's that installment land sale. Okay, and they make payments on the property, and when they finish paying the seller back, then they get title to the property. So we don't see a lot of that nowadays because most people just get a loan, and most sellers don't want to carry paper. Most sellers want to, sell their property and be on with it and go off someplace else. Okay, all right. So that's the distinction between those things. So enforcing the deed of trust, which is in California mostly, mortgage, maybe a second deed of trust, okay, again, and then or my installment land sales contract as defined by Civil Code 2985. You can always go ahead and look that up, okay? All right. It's not supposed to be a class on finance, but if you want it to be, we'll do that another time. Okay, all right. So that was number one, judicial or non-judicial foreclosure. Number two, unlawful detainer. Okay, so somebody is in the possession of the property, and the belief is that they're there illegally, whether it's a tenant that is in there, or maybe a holdover owner. The owner has sold the property or whatever, and now the owner won't leave. Believe it or not, those kinds of things happen. So unlawful detainer, not subject to this. Because that's just going to be essentially a lower court. It's not going to be worth going to superior court over. The filing or enforcement of a mechanics lien. Now, you know what a mechanics lien is. A mechanics lien is a lien by someone who does work on the property who didn't get paid for that work, whether it's, it can be a landscaper, it can be a pool person installing a pool, it can be a lot of things like that. But the law says that they want the protections of the statute, they need to file their mechanics lien. And oh, by the way, there's another interesting law that most of them don't know about. They have to perfect the lien within 90 days. So I've done transactions where there was a mechanics lien filed on the property that the mechanics used to just drop it on there and then just let it sit. Right. And so it would sit for years. And then finally, when it came time to sell the property, everybody's running around trying to find the mechanic. Well, the law has changed to where the fact that they didn't try to perfect it, they didn't file the lawsuit to perfect their mechanics lien within 90 days, then it comes off. Title just takes care of it. Title says, no, we're not gonna worry about it. We'll insure around it. Not a problem. Okay. So those are some of the things that, staying current on the rules is really important. Okay. All right. Number four, any matter that is within the jurisdiction of a couple of big places, okay? One's probate. So remember, probate is a court. Okay, so probate is a court run by the state, and it says, we're going to handle, people who have, properties, personal and real properties of those who have met their demise, those people that have passed away. And so there are probate judges and there are probate attorneys. And most attorneys that I'm aware of that do probate only do probate. I mean, they'll handle little stuff for themselves, but usually probate, it's a big deal. They get paid by the nickel, they get paid by the time that they're working. They don't make quite as much as they might have the potential of making out in the streets, but you know what? It's a guaranteed check. They're they're an officer of the court, and it's a good place for some of them. So it can be, if it's within the matter of that probate court, then you know what? It's going to avoid mediation, because we're not going to force a court to go to mediation. Okay, so if it's in probate court, it's going to court. All right, so I just think that's kind of comical, because people say, well, why can't we require them to mediate? They're the court, right? The mediation is like here, court's like up here. Okay, so all right, so that being said, I've laid the foundation to that would obviously also include my small claims court. And my small claims court, last I checked, was $10,000 limit in the jurisdiction. So, any kind of lawsuit up to 10 grand. If you go to, if you go higher than 10 grand, you're on your way into superior court. And usually by that point, yeah, everybody's got lawyers, right? Okay, so, but in small claims court, people think, oh, attorneys aren't allowed in small claims court. That's not necessarily true. Attorneys can be allowed in there. I mean, especially if they're representative of a firm or somebody, a corporation's being sued or something like that. It's just they don't get any special, privileges for being in there, because small claims court is otherwise known as the people's court or commoners court. It was intended to help the people that just can't afford all this cost of litigation. Okay, so small claims court, I think it's a good place. So the last lawsuit I was involved in a small claims court jurisdiction was $10,000. 99% of the cases that these people see all file for $10,000, right? Because everybody wants to go to the limit, but then you still got to earn it, right? Okay, so you can't just show up, and if the other party didn't get served, you don't win by default. If the other party got served and didn't show up, you probably win by default. But in most cases, not subject to mediation. Again, why? It's a court, small claims court. Okay, bankruptcy. Federal bankruptcy court, we're certainly not going to drag the court down into a mediation. Okay, so if it's subject to bankruptcy court, it's just going to fly off the radar. It's just going to be a big deal. We have a bankruptcy attorney in our office who is an attorney and a broker within our firm, and his practice is bankruptcy. And so it's been amazing for us, how good he is to know the distinctions between what he can say and what he can't say, what he can do and what he can't do. He's very sensitive to conflicts of interest on both sides. And so it's certainly a pleasure working with him, but he is just an amazing young man. So he'll never see this, but if he did, and then he would say, no, I said nice things about him. So we actually have a couple of attorneys working in our office who work for us as licensees. So, okay, so everybody good with that, or bankruptcy court? Everybody good? Questions? We should probably look to see. Nope, we're good. Okay, all right. Moving forward, the filing, once again, here I am, bold print, the filing of a court action to enable the recording of a notice of pending action. So again, notice of lis pendens, okay, Latin for lawsuit pending. So the fact that you file it isn't going to violate this provision. I'll show you why in a second. So to enable the recording of a notice of pending action for order of attachment, receivership, injunction, or other provisional remedies, obviously you got an attorney, once you're doing this stuff, shall not constitute a waiver or violation of the mediation provisions. Okay, why? Because the court wants to make sure that everybody's rights are protected. All right, everybody, whether it's plaintiff or defendant, whatever, everybody's rights are protected. And so they're going to create these rules that are going to say, okay, you can stop everybody, maybe, stop somebody from selling the property really quick, because, you want to avoid that. And so we're going to give them the right to file an action that will stop that and not violate this provision. Okay, so for example, if we're the brokerage, And we don't make it a habit of suing people, but if we were the brokerage and we were going to sue a seller, we might file, over a contract on the sale of their property. We would file a lis pendens. We would have our attorney do it, file lis pendens on the property. That would tie up the property. Anytime they try to do any kind of title transfer, the title company would say, hey, do you know these people got a lis pendens? And most title companies don't want to, insure around it. Unless you post a bond, equal to 3 times the amount of the, this and that and the other. So there's all kinds of requirements. So, maybe I have to file lis pendens to protect my interest in the property so the seller doesn't sell it and go to Lithuania or something. That might be something that I need to do, but that is really only to toll the statute. Number one, toll the time period, so I'm within my statutory period. And then number 2, protect my interest in the property, which is the commission agreement. Okay, everybody good with that? I know I'm giving you a lot. I don't mean to make it a law class. It's not intended to be that way, but I think it's really good material. And if at least you understand it, and please don't, use it to explain it to people, at least as long as you've got it in your head, then you understand what your rights are and that kind of thing. So let's take a look at our last paragraph. And I don't even know what time it is. Okay, good, 1/4 till. So let's take a look at our last paragraph. Let's talk about our advisory, okay? And so we're gonna talk about the advisory, and then I'm gonna show you the arbitration provision. So remember what I said before, I start with mediation, and then I go to either arbitration or litigation, okay? So we're gonna talk about the differences between those 2 things. So in my advisory, if the seller and broker, because those are the parties in the listing agreement, desire to resolve disputes arising between them through arbitration rather than court, they can document their agreement by attaching and signing an arbitration agreement. And we're going to take a look at that agreement here. Okay, but the bottom line is mediation first. If that doesn't work, then you've got a choice, you've got decisions to make, and I'm going to tell you, you've got to make those decisions at the time of the listing. Okay, so when I'm in a dispute with a seller, in my purchase agreement, it's already included in the purchase agreement. So we took out the arbitration provisions from the listing agreement and then consequently from the buyer representation agreement, which is the listing agreement where you list the buyer. Okay, so we took out the arbitration provisions and we said, if you want them to apply, then you have to file a separate document for that, because what was happening was, much like in the purchase agreement, everybody is just kind of having the parties initial it because there's a place to initial, and that's not a reason to initial it, all right? But people are thinking, well, it's a place to initial, so I guess I have to initial it. And I've told you this before when we've talked about, our liquidated damages as an example. Why would I, there are situations where I would not, as a buyer, want to initial liquidated damages. There are situations where, as a seller, I would not want to initial the liquidated damages. And so, but real estate agents are trained to get everybody to initial stuff that's got a place to initial without thinking at all what the ramifications of that are. So that's going to possibly subject you to a lawsuit because you don't understand the principles behind them. And we'll be talking about that a little bit later on the purchase side of things as well, but we're going to talk about arbitration here today for sure. So again, on my purchase agreement, I've got liquidated damages and arbitration, but you'll notice I have liquidated damages and then I have mediation and then I have arbitration, okay? But I don't necessarily have to agree to arbitrate. But again, people are doing it because their brokers are telling them to do it, but the brokers don't really know for sure whether or not that's a good reason to, do you want to arbitrate or not? You need to be asking your client, what do you want to do? Okay, rather than you saying, well, initial here is a place for it, okay, that kind of thing. So don't just assume, okay? All right, so let's talk about that. So if the seller and the broker desire to resolve disputes between them through arbitration, then they can agree to the arbitration provision. So because we don't have it included here in the listing agreement, the default says you're going to court. Okay, so what happens? Talk to your broker, find out what your broker prefers. Your broker's aware of the fact that we took out the arbitration paragraph in the listing agreement. So the default now says we're going to go to court unless you have the client sign the arbitration agreement. And I'm going to tell you, it goes either way. It's whatever your broker tells you to do. Your broker might favor arbitration over litigation. I like going to court. It's fun. For me, it's fun, right? Because I'm not there on my own behalf. I'm usually there on behalf of someone else. So, but we don't want that. That's expensive, okay? So, ask your broker, what should we be doing? Should we be doing letting the contract go the way it is, because if we let the contract go the way it is, then it's going to be, you're going to court, okay? Unless everybody agrees later on, well, wait a minute, we didn't agree to arbitrate, but maybe at this point it's something that can be handled by arbitration. So on the listing agreement side, if the parties decide at some later time, again, you need to get this done in the beginning, but if you didn't, the parties can still agree, okay, why don't we just arbitrate? And now in an arbitration, and I want to show you that, so because this is fun, okay? So let's take a look. I'm going to move us up to the arbitration agreement. If I can remember where I put it. Is this it? That's not it. That's not it. Look at that, 12 years of college. Okay, there it is. Okay, here we go. All right, so let's take a look at my arbitration agreement. And this is going to be, I think this is a fascinating paragraph. And frankly, in the old contracts, in the RLA and the BRE, it was this long. So this is not something that we decided to make it longer because now it's a separate document. This is a very powerful thing. And it's also very binding on the parties. So we want to, be careful. Talk to your broker. Your broker has a position on this. So your broker needs to have one, and they definitely do have one. So let's talk about our agreement. So this is the arbitration agreement. So now, remember what I said before, you're going to court unless you do the arbitration agreement, unless everybody comes together and says, you know what, okay, let's not go to court, let's arbitrate. The contract between the seller and the broker says we're going to go to court. All right, but do you want to offer the possibility of an arbitration? And again, your broker may want to do that. Okay, I can go either way on it. All right, property address goes at the top. Let's talk about arbitration of disputes. So I'm going to move this down just a little bit because I got a couple things to show you. But obviously the property address is going to be important. All right, so let's dig into it. So paragraph number 1, arbitration of disputes. The parties signing below, we're going to call them parties, agree that any dispute or claim in law or equity. So there are two different courts, and this is the old common law. There's a court of law and a court of equity. So court of law says, here's black letter law. It says this, 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 this. Court of equity is kind of like the balancing. The court, in a court of equity, the court says, well, it just wouldn't be fair. Right? And so, we want to talk about fair when we talk about equity. Now, personally, I've said this a million times, but, a fair is a place where you show pigs, right? But you know what? The idea is you can't go down to the court and see that here's court of law, here's court of equity. It just depends on how the judge is doing things, whether they're going to, rule on something based on law, or whether, there's a dispute that is one of those things that doesn't apply in this scenario. And so they may come back and say, you know what? It just wouldn't be fair. Okay. All right. Lee Marvin case, for example. You can look that one up. That was a great case. Okay. Marvin v. Marvin. Okay. All right. So in a court of law or equity, arising or having arisen between them out of the what? So either out of the purchase agreement, okay, or the listing agreement, or the buyer representation agreement. This is what I told you before. Now, in the purchase agreement, the parties, remember that the parties to the purchase agreement are going to be the buyer and the seller. So the broker can offer to be involved in the arbitration. Some brokers are going to want to be involved in the arbitration because the worst thing that can happen is that you're not at the arbitration, and of course the clients throw you under the bus, and then you end up paying for something when if you had been there. Your broker probably wants representation. So remember again what I said, if you get some kind of a letter or some kind of a notice from either the DRE or an attorney or anything like that that has to do with any real estate related issues, you need to take that to your broker. Okay, make sure your broker has this, please. Okay, so that'd be my purchase agreement, my listing agreement. Here we are, we're talking about it. My listing agreement, it's a contract between the seller and the broker, and so we're gonna say, okay, well, we want to be bound by the I pull up my eraser. I'm going to find out where there it is. Okay. So, so in my purchase agreement, I'm going to be bound. In my listing agreement, I want to be bound by this. And this is the more likely scenario since we're talking about the listing agreement. Later on, we will be talking about the buyer representation agreement. And so you'll see that we'll be checking that box again when it comes time to do that. Okay. So, all right, this is going to be my listing agreement or any resulting transaction. okay, which is not settled through mediation. Remember, mediation first shall be decided by neutral binding arbitration. So remember what I said. In mediation, everybody, if y'all don't agree, then, and you don't have to, you have no obligation to agree to what the mediator says. But if you agree, the mediator is going to put it all down on a paper and you're going to sign it. And now you're bound by that contractually. So, there is no trier of fact in a mediation. In an arbitration and in a lawsuit, there absolutely is a trier of fact. So in an arbitration, I've got someone making a decision, you win, you lose, all right? In a court, I've got you win, you lose. In mediation, we're trying to work it out with everybody, okay? So you are going to, by agreeing to do arbitration, you are agreeing to neutral binding arbitration. So this isn't going to be one of those things where we try to work it out and then, okay, go ahead and draft it up. That's mediation. Here, boom, the hammer comes down, okay? Parties also agree to arbitrate any disputes or claims with the broker who have not signed this arbitration agreement. So that would be my scenario where the buyer and the seller are involved in an arbitration between them on the contract, and this is how we bring the broker in. The broker voluntarily would agree, doesn't have to, but the broker would voluntarily agree, who have not signed the arbitration agreement, but who in writing agree to such arbitration prior to or within a reasonable time after this your claim is presented to the broker. So, all of a sudden the arbitrator, remember that is a trier of fact, the arbitrator makes the decision, you know what, we need to go after the deep pockets, we need to go after the broker, and that's why, the broker can now opt themselves in by use of this agreement. So, who is the arbitrator? This is important. Who is the arbitrator? The arbitrator shall be, 1, a retired judge or justice, or an attorney with at least 5 years of transactional law experience, unless everybody agrees to a different one. All right. I'd probably stick with the aforementioned, not the latter, right? I might like the judge. I might like a justice. I might like an attorney with at least 5 years of transactional experience, not necessarily real estate. I'd prefer real estate related experience. I've been involved in enough lawsuits where a general practitioner lawyer was hired, and I can tell you that you really need to make sure that the person that you hired has real estate law a background, okay, so that they can understand what's going on. I was discussing this in a case earlier. The agent put in the counteroffer COE +3. And so the judge in court says, what does COE mean? And I said, well, I thought it was circle of excellence. And so obviously that wasn't what it meant. And I said, well, in the vernacular, which of course nobody knew except for the agent, right, that meant close of escrow. So let's try not to use those cute little terms. I would prefer that we use, real English, that kind of thing. Okay, the Queen's English, as we say. All right, so the parties shall have the right to discovery. That's important, okay? Discovery means I'll show you mine, you show me yours. I will show you my evidence, and this is to encourage settlement, right? So I'll show you my evidence if you show me your evidence. And by the way, the rules of evidence apply. So Civil Code 1283.05, Code of Civil Procedure, so the rules of evidence apply. And if you don't produce it to the other side to look at it, okay, because remember, they might look at it and say, oh boy, this one, we're going to lose this, so we might want to settle really fast. That's the point behind discovery, okay? But you think you're going to have a sneak attack and drop everything on them in an arbitration, and the judge is going to say, nope, you didn't allow them to review it ahead of time, and I don't have to allow it to be entered into the case. So that's going to be an important part, okay? I like discovery. In all other respects, the arbitration shall be conducted in accordance with the Code of Title IX, Part 3 of the Code of Civil Procedure. Judgment upon the award of the arbitrator may be entered into any court having jurisdiction. So in other words, once the arbitrator makes a decision, much like when the judge makes a decision, I can now take that decision and enter it into the court for enforcement, okay? By the way, also credit, things like that. So there's a lot I can do with that judgment. Judgment can be in any court having jurisdiction. Enforcement of this arbitration agreement shall be governed by the Federal Arbitration Act. Exclusions are specified as below. So remember, we also have to have a provision for enforcement, and the arbitrator doesn't want to be the enforcer. The arbitrator wants to be the person who renders the decision, But you know what? You guys are going to have to figure it out yourself as far as enforcing it is concerned. And there are rules that apply to that as well, okay? And I've already given you a couple things you can do. So let's take a look at some of the exclusions from arbitration. They're specified below. I'm sorry, they're going to be specified below, but that's going to be under 2. So let's take a look at notice. Notice, first of all, 10-point bold font. Why is it in 10-point bold font? Because the law says this is so important that you need to put it in red if it's going to be the same size font as the rest of your document. So the rest of our document is in 6-point font, 6-point black font. But you know what? We just assume that you don't have a printer that will print in red. So the law says if you can't put it in red, then you have to put it in 10-point bold. And that's the point behind all of this. That's why you see 10-point bold font in our purchase agreements. Okay, everybody good with that? All right. Okay. That being said, let's move forward. I just can't believe we are as far as we are. So let's take a look. What does it say? By initialing in the space below, and I want this. I'm going to move, folks. I'm going to move the screen, or not move the screen, but move the document a little bit because I want you to see how important this is. This does require a separate initial. You wouldn't be here if you didn't want it to apply. So by initialing in the space, do that every time. By initialing in the space below, you are agreeing to have any dispute arising out of the matters included in the Arbitration of Disputes provision decided by neutral arbitration as provided by California law, and you are giving up any rights you might possess to have the dispute litigated in a court or jury trial. So I was telling this joke the other day to an attorney. We were discussing, you know, a jury of my peers, and they very kindly responded that I don't have any. So I thought that was thank you. I really appreciated that. But they were saying that I don't have a jury of my peers. I could never get one, right? So I just thought that was very kind. But the point is, you are giving up your right to court. You're giving up your right to a jury trial. Now, what are the advantages? What are the disadvantages? One of the advantages is you're in front of an arbitrator in less than 3 months. You're in front of a court 2 years right now, 3-4 years. I just came out of a case that we did a year ago where we were successful at trial, where it's been 3 years. Folks, you know what that looks like in attorney's fees? It was $1 million on each side. Okay, I got called into a case on a commercial dispute where each of the attorneys had $1 million. Each side had $1 million in attorney's fees before they called me. And you know, I didn't have what, 50 grand. I mean, in little stuff. But you know, it's a lot of money when we do that. So those are going to be decisions that your broker is going to decide as to whether or not I want to arbitrate versus litigate. And so there's a lot of reasons why. But remember, either way, and I've heard people say either way, it takes you 3 years in an arbitration or 3 years in court to get to the same lousy decision. So I don't know that the decisions are lousy, but whenever you have someone else decide, there's always somebody that's going to be unhappy. Somebody's going to win, somebody's going to lose. So you know what? It's a decision to be made, and your broker's going to have to balance the equities on the decision on which way to go with this, whether they're going to do arbitration. I'm going to tell you, most people would rather have arbitration, but when we took out that paragraph so that now we just reference it, you know, in the contract, you know, we took it out of the paragraph. You all can see that, yes. So when we took it out of the contract, people don't do it anymore. Well, you need to really decide. Ask your broker, what is our position on this? Do we want arbitration to apply? And your broker may say, yeah, make sure you have them sign that form. We have it in our Zip Forms program. It's in there. You know, a lot of times we don't even sign it. And part of the reason that we don't is because, you know, we'd rather go to court. But, you know, that's fine. And we could always decide later, well, let's arbitrate it instead. We can always make that decision, right? Okay. All right. So that being said, let's take a look. Jury trial. By initialing in the space below, you are giving up your judicial rights to discovery and appeal, which makes no sense because up here it says that you're going to have the right to discovery, okay? But you do not have a right to appeal. You won't have a right to appeal in an arbitration once the decision of the trier of fact is going to be final. The only thing you can appeal would be a violation of a rule of law. So in other words, they just misapplied the law. That's the only thing you can appeal. You can't appeal the decision. You can't say, I want to see the case again, because the answer is you already decided that you would arbitrate and you would agree to do that. Yet remember, you can take an attorney to your arbitration. You're not precluded from having an attorney. So you can take your attorney to mediation. You can take your attorney to arbitration. You certainly want to take your attorney to trial. Okay, you definitely want to be doing those things. Unless those rights are specifically included in the Arbitration of Disputes provision, which it is. If you refuse to submit to arbitration after agreeing to it, you may be compelled to arbitrate under the authority of California's Civil Code of Procedure. Your agreement to this arbitration is voluntary. We want everybody to know you do not have to agree to arbitrate. You can require that everything go to litigation. You can do that. So again, ask your broker, because your broker's going to have a position on that. Let them make that decision for you, okay? All right. We have read and understand the foregoing and agree to submit disputes arising out of the matters included in the Arbitration Disputes provision to neutral arbitration. So you see over here, I've either got the seller, buyer, but over here I'm going to have the broker or the agent. I'm going to recommend that you have the broker do it, right? I think the broker should be initialing that, but only because the broker is the one who's going to be bound. If you initial it as the sales associate, whether it's the broker associate or salesperson's associate, then you may be binding your broker, okay? So your broker, if your broker says later on, hey, wait a minute, I have a policy against that, then you may have a problem, okay? But you can see that it requires a separate initial, even though it's on a separate form. We need everybody to understand that, okay? All right, so let's take a look at a couple more things really quick. I think I've covered most everything that I have to cover. So let's take a look. Paragraph number 2 is additional arbitration terms. And so guess what? Does this one look familiar to you? Number A, exclusions. Does that look familiar? It's the same stuff you saw earlier on mediation, so I'm not going to go through it again because it talks about the same things, right? Judicial, non-judicial foreclosure, unlawful detainer, any matter within the jurisdiction of probate, small claims, and bankruptcy, okay? Same rule, same provision, those things you just cannot, you're not going to drag a court into court. It's just not going to happen. Cracks me up, but it's not going to happen. Okay, all right, so let's move down a little bit. Preservation of actions now. The following shall not constitute a waiver. Same kind of stuff before. The filing of the court action preserves the statute of limitations, right? It just says I'm going to keep you from, disposing of the subject matter of our litigation by filing an action against it, my lis pendens or whatever here, and then all my other stuff in here. Okay, so all this stuff is pretty familiar. You had this before. All right, questions on any of that? Okay, good. I can see if you're watching. No, I can't, but anyway, people are like, wow, I just leave you in the background. Okay, number C, let's talk about number C. So brokers who have not signed this arbitration agreement shall not be obligated nor compelled to arbitrate unless they agree to do so in writing, right, up here, initial. Any broker participating in arbitration but who have not signed this agreement shall not be deemed a party to this arbitration agreement. So if you have not signed it, then you are not a party to it. You have to agree or not agree, one or the other. And again, I'm going to ask you, please check with your broker. What is your broker's policy over whether or not do we arbitrate or do we litigate in lawsuits with the seller? Okay, in a listing agreement, we may not have any choice in a lawsuit between the buyer and the seller. A lot of times the attorneys are looking for deep pockets. They're looking for something, the broker has E&O insurance. Now we know we've got somebody we can chase, that kind of thing. So you may end up being in there anyway, okay? So just understand that the broker has to independently agree to this, and so does the seller, but you need to be aware this form is available. When we created the new form, it got buried. Right? Well, it wasn't really buried, folks, because remember, I'm going to take you back to the other screen here for a second. Just remember that we had this language, additional mediation terms, but then here's paragraph number C. Look at this tiny little paragraph, not even in bold print. Okay, so if everybody desires to arbitrate rather than court, they can document it by doing the CAR form ARB. Now, I have a problem with that, okay? In the old, and then again, when I look at that document, it's going to show, this stuff's in bold print. It's in bold print for a reason, okay? It's an important topic. It's an important subject to consider, and you need your broker's advice on whether to do it or not. And I've said that about 20 times here, and so please check with your broker. When we take listings, do we want our arbitration to apply? If so, you need to take this in the file with you. Okay, everybody good with that? All right, any other questions as we've gone along here today? Deanne, you might not deal so much with this because of how you are involved in the real estate transaction, but it's important for a listing agent to have that done. Remember, you can agree to do it at any time, but you run the risk that the other side, the seller or the broker, you the broker, might decide you don't want to do it. So the idea behind getting it at the time of the listing is going to compel everybody to do arbitration. But you could still go 6 weeks into it and then just decide, okay, all right, we'll all agree to arbitrate, in which case I'm going to recommend that everybody sign that agreement. Okay, but other than that, there's no obligation unless you are bound by contract. Okay, ask you about this offline. Yeah, so here's our position as real estate agents and transaction coordinators. Okay, as transaction coordinators, we do what our broker tells us to do. All right. If you are not affiliated with the brokerage, that's going to create additional problems. But remember, at the end of the day, the truth will set you free. So I'm going to suggest that you follow the advice of the broker. You find out from the broker whether or not, and if you're the TC and you're a TC coming in from outside, then, it's none of your business. It's either in the file or it isn't, right? Because you can't give legal advice to the agent. The agent should be getting that advice from their broker. So, you just, whatever you got in the file, right? Okay, that's the way to handle it, all right? So, but as an individual salesperson licensee, you've got a contract with your broker that says what they want you to do. And that is whether or not they want to be bound by an arbitration provision or whether or not they want to be bound by whether they want to go to court. So different things for different people. But as a salesperson, I'm in great shape. As a sales associate, I'm just going to sit back and do whatever I'm instructed to do by my broker. As a transaction coordinator, same thing. And I know we got a couple of transaction coordinators on here today, but I'm going to be I'm going to be doing things. Remember, as the transaction coordinator, you are not allowed to create forms. Okay, only at the instruction of the broker. So if you are internal, then you know what, the broker can tell you what to do as an employee. But if you are an external TC, then you have some other complications, and that is that you can't give them legal advice. You can't pull forms in. You're not supposed to be creating transactions. You're supposed to only be shuffling transactions around, shuffling paperwork around. You are not allowed to create anything. That would be the unlawful practice of law. So we don't want to do that. Okay. So any other questions on any of that material? And Deanna, if you still want to reach out to me, more than happy to have that conversation with you, probably on the phone. Good. Okay. Seeing no questions, tomorrow we're going to be doing at 10 a.m. We're going to be doing Home Snap, and that'll be for an hour. Not a lot of time. It'll be an introduction to it. Kind of a neat little program. And then in the afternoon at 1 o'clock, we'll be launching into the RPA, and we're going to be talking about paragraph number 14. So paragraph number 14 is, well, 13 and 14. 14 is the one we're going to really want to get to fast. That's going to be my time periods. So I like time periods. I like everybody paying attention to time periods. And I bet you it's going to say stuff that we didn't know it said. So thank you all for being here. Seeing no other questions, I want to thank you for being here, and I want to wish you a very good afternoon here on a Wednesday, and I look forward to possibly seeing you tomorrow. Thank you all. Take care for now.